So at the outset, when this topic or thinking about this topic, we have two words which we use interchangeably, and sometimes I would say we get the same meaning when we look into many articles. So whatever I understood, let me clarify first. Techniques for data collection and tools for data collection. We have two words here. So what I understood is that we have several tools like questionnaire or say observation method or many methods, tools we have. But each method has its own way of implementing it. For example, we have an interview tool. It's a tool of collecting data, but what interview are you going to take? Are you going to take directly or email or through telephonic interview? We have so many things. So how you are going to proceed it further, that is actually technique. Okay, so that's how I have understood the words, and I am going to use throughout this presentation. So the means of gathering data with the use of specified tools that are used in given methods are known as techniques. That's what I will be proceeding like that. And at the outset, I would like to tell that I will be proceeding this techniques for data collection in the legal research. I am going to take forward you through legal research and how in legal research you have to collect data, because we all belong to that field, I suppose, right? So first thing, why legal research? This question needs to be answered among all of us before starting a legal research. That's what I feel. Because many times in choosing a topic or giving a research proposal itself, students or even PhD research scholars are not clear about what we are going to do, right? So we have to have an answer with us why I am doing this research, especially legal research. So legal research can be done by, I'm sorry, I'm sorry, it's not moving. 1 second. Yeah. This PowerPoint is not moving. Is it going forward? No. I'm sorry. 1 second. There's some technical issue. Means my PowerPoint is not moving. It got stuck. I'm extremely sorry for that. Okay, once again I'll share. Yeah, yes, I'm sorry for that interruption. Okay, so to contribute to the existing knowledge of law, that's the first thing, the answer when we ask a question as to why we are doing a legal research is because first thing, we have to contribute something to the, I would say, the legal field, the existing knowledge of law. Already there is something there, right? From there we start and we proceeding it, we are going forward to contribute to the existing knowledge of law. That is why all of our teachers and our professors will tell, please do review of literature first and then you start finding out. And even if you say a topic to professors, they will say, do you have materials for that? This seems to be a very small topic. Like that, the doubt comes. So first we have to decide already if something is there, whether I am going to proceed forward. Because in contributing to the knowledge, when we say it is going to make a positive impact on the state of knowledge in a particular discipline, in the sense it will expand its horizons. So the researcher will be able to contribute and tell there is something more to think in this. This is not the way it should have been interpreted. There is another side for it. Critical evaluation, I mean, right? So that's one reason why legal researchers need to be done and we are doing, okay? And the next thing is to inform policy making. This is again another very important reason why legal researches should be carried out or must be carried out. Because as we go, we find that some places or some, I would say some, for example, sexual harassment of women in working places. Until Vishaka judgment came, we did not have anything in the, I would say, We did not have anything to say what is sexual harassment of women in working places, or is there any definition, or like that. So there were researchers who did and contributed saying there must be a specific law, any topic like that. So it resulted in the policy making, right? So your research is going to result in policy making. So that's also the reason why legal researchers should be done, because this is a wonderful contribution which we can make to the society. Because there are many fields where in legal research itself people search for a topic and roam about, but there are still places where there is a gap. It still does not have a law, or who is going to protect these people? There are empty number of subjects like that in legal research also, right? And to address a specific issue or question, this is also the reason why legal research needs to be conducted. Because, say, implementation of a law, maybe action research, we call this. Already law is there, but the way it is implemented is not satisfying. Who will tell this? Legal researchers have to do that. Go to the society, ask questions, or find data to say that this is not done properly. Already there is a law, but it is not reflecting. So that is also the reason why. So contribute to the research, whether you are going to expand the horizons, or whether you are going to suggest a policy already it is not there, or whether you are going to find out, answer some specific issue. For example, law is there, but how far it is implemented in Chennai, I can do, right? So specific, why it is not implemented among law students, or why the legal knowledge is like this. So anything it can be, such topics. These things are the answer to the question, why legal researcher? So before you go for a data collection, or before even you check out something, you as a researcher individually must answer this question: what I am going to do with this topic? This is my topic, whether this topic is fitting in within these three walls, right? Next is legal research. Every time when we say legal research, pure legal research, something called only law, only the theories or doctrines and all we say. But in fact, I feel, maybe it's my opinion, law does not sit in a vacuum. Instead, it operates in a complex social context. Always the law is for the public or the people or for the society, something like that, right? So definitely it is not in one corner alone. You can study law alone, you cannot, because as Roscoe Pound has said, law is a social lawyers are social engineering theory, we say social engineers we are. So we have to go to the society many times. So it becomes essential for ascertainment of the law, and to point out ambiguities and weaknesses of law, and to critically examine the laws in order to ensure coherence and stability, consistency, and its underlying policy, and the conduct a social audit of the law, and finally, thereby you suggest reforms in the law. So this is the picture which we should have in hand, whatever research you do. Maybe even you are doing a very pure research, not socio-legal research, but still ultimately what you are going to contribute in the legal field, that must be in our mind when we do a legal research. For all legal researchers, I think this has to be in the mind, because sometimes we will be able to point out the ambiguities. Legislators have made the law, correct, but a certain process in that, or certain sections in that, maybe in one act, maybe two sections are ambiguous, it's not clear. If a situation comes like this, what will happen? So that we can answer, and thereby you can give a certainty to the law in order to do, or sometimes we may have to do a social auditing of the law and thereby suggest reforms in the law. So legal research is actually doing this to the society. Now, when it comes to legal research, it is performed between two common methods: doctrinal or empirical, that is non-doctrinal methods. This everybody knows. I think commonly we use this. And following any one method out of the two distinct sources of data, nature of data, and their collection methods will vary in these two methods. Many times, doctrinal researchers feel that, oh, what is there? What data collection? Do we have anything to do? This always happens. Especially legal researchers, they say we have only library. That is our, yes, exactly correct. But when it comes to this method which you are going to follow, are you going to take up empirical research or are you going to take up doctrinal research? Whichever method you follow, data collection is important and inevitable. And sometimes we can even mix, that is, in the same research, one portion of it, maybe we will have to collect empirical data. Otherwise, it is a doctrinal research. So, from the library, books, what, etc. I will be proceeding in that topic further for doctrinal research also. It's a mix. And one thing we have to remember, everyone, because nowadays we have a trend which I see is that even among experts, when we go and submit our pre-viva presentations or when there is an external, the question that comes is why you did not do empirical study. The point here I would like to convey to all the young research scholars and the students and all is that the topic which you choose, when you reflect it in the title, that should not give an impression to the examiner that this topic needs empirical data. So whether I should go for empirical or whether I can confine to doctrinal study, I have to decide first, and that must be reflected in your title. Because I have seen titles like implementation of some act or some provision or something like that, and it is a doctrinal study, they will say. The methodology, when they come to explain, they will say it is doctrinal. So when you say implementation, you are out to the society. So you are going to conduct a social auditing. But when you say doctrinal, there comes the controversy. So when you choose topic and when you are fixing the title for it, I think we must be clear as to which method are we going to adopt. That is where students find it difficult to answer in a pre-viva or open viva or in a doctoral committee. We find that. So watch up to that. First, decide ourselves, because I'm very sure there is, I think even previous speakers of this FDP, I heard many experts saying there is nothing wrong in doing doctrinal. Nowadays we feel, oh, I did not do non-doctrinal, how will mine be received? Nothing like that. Both are equally good. There was a time when legal research was done only doctrinally. Non-doctrinal, empirical and all came very late, right? So there's nothing wrong. We can contribute enough even in doctrinal study, but ethically it should be followed, right? Now, ascertaining the law. When I said ascertaining the law, a researcher, in order to find out his data, needs to look, analyze, and understand the pronouncements. That is, we have judicial decisions coming up every now and then on the topic. You will find, if you can draw a graph on certain topics pronounced or judicial pronouncements, if you collect the cases and then analyze the cases, we will find that there is a model or there is a change that has happened in the judicial pronouncements itself. Abruptly, we know Maneka Gandhi's case and all. Before, after, we say. Article 21 before Maneka Gandhi, Article 21 after Maneka Gandhi, we say. That's one very common, everybody knows exam. But in all judicial pronouncements, anyone, maybe one section only we are looking into. But if you analyze the cases and the legal changes, that is, legislations would have come up, amendments would have come up, all this when you look into, you will find that there is a change taking place, or sometimes reformation itself would have taken place, right? So this is also a research. You can ascertain the law. So you have to see the provisions, you have to read the statutes, you have to see the judicial pronouncements, analyze and give a conclusion that this is how the law is now. Earlier it was like this, now it is like this. So ascertaining the law, this is also legal research only, and highlighting the ambiguities and gaps. So a law is many times it is not designed to address every contingency that will arise in the future. That's why we have amendments, right? The purpose of amendments itself is that only. Definitely there will be ambiguities, or definitely a case would change the whole scenario. Amendments would be needed. So this also, legal researcher, while collecting data, he has to keep in mind, okay, where are we proceeding into? So only with cases also, yes, researches can be done. And the legislative intent has to be brought forward through reading these judgments. So while you read judgments, that's why always all of our professors would have told us, please read the full judgment. Only till graduation, even in graduation, you are supposed to read the full judgment. But at least till graduation, they say it was held, Supreme Court held like this, it will go like this. Okay. But after that, no, it was held. You have to ask a question why it was held like this. What is the reasoning of the court? How did they conclude like this? 10 years before, what was the judgment on the same topic? You can analyze and bring out the legislative intent many times by analyzing the provisions, statutes, case laws, etc. This is legal research, in fact. And to determine the stability and coherence or consistency, when I say the process of critical evaluation of the law, a researcher can exhibit the consistency. So this helps in future designing and development of law, legal provision or doctrine as the case may be. Whenever we read doctrines developed by sometimes judiciary or while interpreting only, we read doctrines, right? Doctrine of indoor management. I think in our what is that, company law, in that subject, because I'm commercial, I'm just telling. So many doctrines come up. So doctrine of indoor management, constructive notice, etc., we say. But how did they arrive at that? These doctrines, whether it is applicable today at all, whether it will enhance the corporate governance at all. So are we able to apply this doctrine today? Because sufficient number of exceptions have been held by the courts itself regarding the doctrine of indoor management. So in that case, then what is the use? Doctrine, they said, now they say exceptions, enough number of exceptions. Many of the doctrines are known to us only by exceptions like that. So then what happened? So is it really applicable? We say company is a legal person. Yes. Solomon's case. From there, we will start company is an artificial person. Like any teacher of company law goes to the class. I think from the first class, we have to teach Solomon versus Solomon. But is it really true? In that case, then how company CEOs are now arrested or they are into scams and their action is being taken? Then we say lifting of corporate veil. Okay. So then another doctrine comes in fact, reverse lifting of corporate veil is also there. So I think we have to read, evaluate the process that has taken place on a particular topic. I'm just giving an example in company law, but for all topics, this will apply because this will help in future designing and development of the law. And I think there's a problem with the share. Yeah. Yes. So social auditing of law, I said. So it is sometimes, many times, it is a pre-legislative step done in order to understand and appreciate the social factors that had an impact on the making of the law. Am I audible? Is it okay?
Yes, ma'am.
Yeah. So it enables the social auditing will help in knowing the states the law intends to protect or change and reasons for the same. So such an audit will help in identifying the gap, if any, between the legal ideal and the social reality and to know the reasons responsible thereof. When I say social auditing, in fact, this is mostly contributed by legal researchers. We find, many times before making a law or before a bill would have come, there would be a committee appointed, high level committee appointed by the government itself many times. And they will search, analyze, do everything. Sometimes they will suggest there is a need for a law. There is a need for only amendment. They will say completely the law must be repealed and the new one will come. Yes, this is actually social auditing that is being done, right? So it also enables us to predict the future of the law. So suggesting reforms in the light of the research can be proposed in precise terms in this type of legal researches. So this outcomes, how can you do this social auditing? I mean, social auditing type of legal researches. Topics can be taken like that also. on the basis of analytical, historical, and comparative research. So you have to follow these methods so that you suggest that this is what is happening in the society. For this, you need a law. Sometimes already law is there, but it is not suiting to the needs of the present day times. For example, MRTP Act was already there, Monopolistic Restrictive Trade Practices Act. 1969 itself it is there. But in 2002, it has changed and it has come up with Competition Act. Today, monopoly, no, that word and all is gone. Now it is to Competition Act 2002. So how did they come to this conclusion that we need such things? So something is researched and found out that yes, that MRTP Act is not able to cope up with the globalization or the era of globalization. It is not able to handle the issues that has taken place. Now, this is also a very good research. You have so many laws now. But I am not saying that you have to take the entire law, because that is a committee appointed. Raghavan committee was appointed. They analyzed the whole law. But as a researcher, you will be able to research on a specific small issue taking up. Because I have seen people choosing a topic saying critical evaluation of the entire act. Researches cannot be done like that. As a PhD or a dissertation, LLM dissertation or an article, you take it small and expand and do. So that is how we do. Social auditing of the law also can be done, right? And everybody knows all this, but just brushing up kinds of legal research. If you take, one of the traditional classifications is pure and applied research, right? Either way or. So pure in the sense analysis of theories, and applied research is concerned with testing the theories in the real world, applicability, right? Depending upon the nature of the research question, the legal research is also classified as descriptive and exploratory one, right? Descriptive in the sense to describe a situation, problem, phenomenon, or behavior systematically. So it's actually what it is trying to do. Descriptive research is what was already complicated, the researcher is trying to bring an understandable and a simple version. So this is what I'm telling to the world. See, this is how it is there. That's you describe and you are going away. But exploratory research is undertaken to explore areas about which the researcher has little or no knowledge. So it enables the researcher to formulate problems for more in-depth study, develop hypotheses, and find the best solution. So it involves findings, the reason for things, events, and situations, showing why and how they have come to be what they are. So we are going into the field and trying to find out, okay, these are. But here again, don't think that always we have to go to the society, collect data from people. No, I am not of the view that. I'm talking about cases, analysis, even that, or reports by various institutions that also can be used, right? Now, conceptual and empirical research, that's how doctrinal, non-doctrinal we say. It's conceptual is only an idea, notion. We analyze that. Generally, it is resorted to by the philosophers and thinkers to develop new concepts or reinterpret the existing concepts. Here, you have to be very good in interpretation, such researches. Then only you interpret and give it a different meaning and come out with this. But when we say empirical, it is based upon experience and observation. So it is definitely empirical, means data based, coming with results that can be verified by observations and experiments. So that's why I told in the beginning, when you design your title itself, you must be clear as to whether I am going to find out the reality or I am going to only analyze the theories and concepts. That first the researcher must be clear. Then it is very easy to proceed further, because there is a tendency towards students today. We take a broad topic. Say I took corporate social responsibility, and I go to the library, collect everything under the head corporate social responsibility and keep it ourselves. Everything I will collect and I will keep it. In fact, whether these are useful, whether it can be put inside the topic which I want. Did I ask a question in corporate social? What is the issue? They will not answer. Many times that happens. So before going, corporate social responsibility is your area. Okay. You have narrowed down from company law, broad one, corporate governance, little one, again little one, corporate social responsibility, very good. But after that, in corporate social responsibility, what is your issue? Is there anything to tell? Because some years before, that is Companies Act 2013 came, before that it was 56 Act. Under 1956 Act, there was no section, or specifically corporate social responsibility was not mandatory. Now it is mandatory. So before 2013, if anyone has done such a topic, maybe they would have concluded by saying we need a specific section, it's absent, so we need to make it mandatory. Like that, we can finish corporate social responsibility. But today, if you do corporate social responsibility, what will happen is everything is settled. What is your problem? Yes, there is a section under Companies Act and it has been implemented. What is your issue? We have no answer. Don't mistake me. I'm taking all the examples from company law and yes, commercial law, because my background, I'm teaching that. That's why. If other topics, if anyone has a doubt also, we can analyze. No problem, right? And the other major methods used in legal research is, as usual, I said, doctrinal law research. The inquiry is what is the law on a particular issue. It is concerned with finding the law, rigorously analyzing it, and coming up with a logical reasoning behind it, right? And it is immensely contributing to the community consistency and certainty of the law. So I am repeatedly telling, don't worry if anyone has proceeded to go forward with doctrinal research, because always there is a fear whether I am going in the right direction for every scholar. And the basic material can be found in the statutes, primary sources, as well as the secondary material. However, in doctrinal, the limitation is it is subjective. That is, it is limited to the perception of the researcher, away from the working of the law. It's devoid of any factors that lie outside the periphery of the law, and it fails to find out the actual practice of the courts. So now I am giving you a reply as to why people are telling why you have not collected data, why doctrinal research, why it is becoming a failure, or why people feel when questions are asked in open vivas, no, this is wrong, that, this and all, when they say the reason is this. We do not try to analyze the actual practice. Or sometimes, or many times in doctrinal research, our perception comes inside. But for that, doctrinal research to be successful, first thing we have to keep in mind is the researcher should be unbiased. When you approach a topic itself, don't approach that this should be the result. If that is avoided, then doctrinal research can be successful, very successful. Only limitation is your own thoughts should not be come inside. For example, women's issues, right? Women's rights, health rights of women, something like that. My topic itself is reproductive rights of women. I should not approach the topic that there is some problem there. Need not be. I am only going to find out, right? I am interpreting the law or the bill or the provision or something has come. I am trying to interpret in my own way, correct? But while I am interpreting, I must not trust my ideas on anybody. So if that can be, I can be clear that I will be unbiased, I will study and then I will tell, then okay. You have to study primary sources, secondary sources, everything. Then doctrinal research is also equally good, okay? And non-doctrinal legal research, also known as socio-legal research. Nowadays, it's on the trend. Everybody tries to do that only. It looks into how the law and the legal institutions molds and affects the society. It employs methods taken from other disciplines in order to generate an empirical data to answer the question. Why we name it as socio-legal research is because earlier sociology, now law, both were so separate and somewhere it is. But in fact, this law is also applicable there only to the society. So if we can connect the sociological issues with our legal doctrines and try to analyze whether there is any connection, then yes, then only we are bringing out a good non-doctrinal legal research. When we talk about non-doctrinal legal research or socio-legal research, people immediately from, say, exclusively somebody from sociology will feel, okay, this is not correct what they are saying. But we are only using the empirical data partially. That is, sociological part alone, we are collecting data. But to write to legal or connect it with legal, we need to do some doctrinal work, or our own cases and statutes and legislations only will help, right? I can give an example. That is, now take for example women's rights itself, we will take. Whether the, say now, reproductive rights, assisted reproductive technologies are available today, but it is available only in big hospitals or private hospitals. Who is funding this? Whether a person from a very rural background or maybe a poor somebody, not very much able to spend money, are they able to avail these reproductive technologies that are available with big money? Because for per sitting they will say lakhs. People who have gone say that. So as a socio-legal research, right, I have to first answer the question economically, or say whether this reproductive technologies, the relationship between this technology and money, whether economically people sound only are able to use this. That maybe I have to collect the data only. Socially, I have to collect the data. Then come here. I am answering whether financially sound people alone are able to avail the reproductive technologies. That was my hypothesis there to find out, and I analyzed, or I collected data. I inquired all the people who availed these services. I went to them, spoke to them. Okay, I went to the rural people also, poor people also. There may be people with problems, but why have you not approached these services? Okay, whether money is the background, everything I analyzed. Then I come back to my law and say, okay, legally, this is the act, this is the bill. So far, bill has not even been passed. That is the reason why. So I am taking data from the public. So it's answering a problem, like to find the gap between the idealism and the social reality. And then I read into legal decisions whether anybody has filed a case. And in that case, what Supreme Court told, the statute, whether there is any legislation protecting this, whether the state government is doing something like this. State means any state. So all the legal factors I have to study. Now it is called socio-legal research, right? From my own experience, only I'm just telling. And it's about viewing law from the perspective of a different discipline. Now, people who study family law has to read sociology, I think. Right? And people who read only, that is why in 5-year courses we have sociology. It's about sociology for the purpose of studying the future subjects like family law, social theories, and etc. That's why we study that. Economics, like that, for all business law subjects, economics is the background. So till now we were telling that's a different subject, this is a different subject. But in socio-legal research, we are trying to mingle this. So it is very vital. In fact, this is what we need today, because we can study the practice and procedures and their impact on the range of social institutions like family, businesses, citizens, consumers. Like this, we can study. So non-doctrinal legal research is also equally important. But when I say non-doctrinal, yes, we have to go to the society, collect data, and then link it with the legal part of it, and I should continue. Now, comparative legal research. This involves a comparison of legal doctrines, legislations vis-a-vis the foreign laws. All this, you might think I am only talking about kinds of legal research which everybody knows. No. For data collection, you have to understand this basic, and then only your data collection will be right. For example, a person who does comparative legal research, in fact, many students sometimes misunderstand. When we say comparative legal research, take a topic or a specific issue and you are comparing it with the other country's laws. So it may be other countries' legislations, how it has been adopted that. So it is very useful in developing and amending and modifying the law in our country. But one very important thing we have to remember is cautious approach. don't blindly compare anything. Because suppose India, okay, I'm doing research in India, I take up a topic, straight away everywhere we will see US, UK, European Union, we will see. Why European Union? Why US? India is a developing nation, that is all developed nations. Sometimes they take unconnected some country. Why are you connecting? So in all comparative legal research, when you are collecting data, you have to first justify why you are comparing with that country. Because in every thesis or in every dissertation, one chapter comparison, ma'am, will they'll say. So comparison means what students nowadays think is that, even I was thinking some time back. The thing is, I have to tell the position in US, I have to tell the position in UK. That's all, my comparison is over. No, actually that is wrong. You have to tell the position in US, you have to tell the position in UK or Australia or European Union, take any country, but first give an answer why you are comparing. Number two, how you are going to tell that this particular provision, while compared, I found that in India, if it is applicable, it will be good. Because we ourselves have heard constitution while drafters, they got examples from outside. We say directive principles is taken from this country, DPSP is taken from this country, correct? But directly you can't take that and apply in India many times, because it's another social setting. So that societal setup, the governmental setup, the people who rule, everything will be different. Of course, the law is good. Because of that, in that country, this progress has taken place. That is why I'm suggesting that similar circumstances are in India where we can apply. Like that, if you compare only, it is comparative legal research. So in comparative legal research, while we are collecting data, we should be careful. Don't take a big one, full act you take here and sit there and compare. No. Take a small provision, similar provision, whether it is available in any other country, okay, in that country, how they are implementing it, that also should be studied. So today we are living in a global context. We are talking about global legal education. Definitely comparison is very good, so that we are exposed to various countries' legal provisions, right? And quantitative and qualitative legal research or data, again, we are talking about that. Quantity or amount. Quantitative means whatever can be cited in numbers, which can be expressed in numerical form of results. But in qualitative, certain things cannot be theory, doctrines, etc. We cannot go in terms of numbers. So we collect in that fashion, right? They use their analytical techniques, the researchers, and they will put up their views regarding their doctrines, and qualitative research is being carried out. And now coming to elements of data collection. First thing, data collection is a very, very demanding job. First, understand that, yes, data collection, once you collect it properly, codify it, that itself, half of your research is over. But sometimes, or many times, even I, while doing research, say 3 years is our minimum period, somebody asks, okay, how is it? How is research going now? Data collection. That will be the answer given by us. But what are we really doing? Sometimes 2 years will get over. That time also we will say data collection. Please understand, data collection is a very demanding job. For that, first thing is we need planning. That is why I gave a background of what legal research is and what are the kinds available there. So first decide, you plan that, yes, this is what I am going to do. Don't worry about others. Many comments will come. This can be done. This cannot be done. Oh, that and all settled position. What is there to research in that? Like this, so many opinions will come. If you are planning, it can be done. It's yours. So hard work, patience, perseverance is very, very important for data collection. Because many times, again, example, half the way or maybe after 1 year, sometimes students are stuck by saying, there is no data available, ma'am, nothing can be done in this, I'll change my topic. That cannot be done. Nowadays, in research, especially PhD, most of the universities, they have doctoral committee. And in the doctoral committee, you have to first present yourself. And for the first 6 months itself, you are finalizing your topic and you are going for coursework, etc., based on that topic only. So after 1 year, after doing coursework also, suddenly you tell, oh no, there is no data, I cannot do. It cannot be done. So in the beginning itself, be sure of what you're going to do. And then only your methods and tools for data collection will take you to the right direction. Because data collection is a process of gathering and measuring information on variables of interest in an established systematic fashion that enables one to answer your research questions. So first you should have research questions. Then only you can collect data based on that. Test your hypothesis and evaluate your outcomes. For all this, first you need research questions. Without even knowing what I am going to collect, as I told you in the beginning, corporate social responsibility. Anything under the heading I cannot collect. There will be hundreds of authors who have wrote about corporate social responsibility in their own country, in their own fashion, or in their own company aspects, right? Even business economics people would have done that research. That cannot be applied here, right? Your research question should be clarified. And two, regardless of the field of the study or preference of defining the data, accurate data collection. In doctoral research, especially, you need to answer the question, or while you are interpreting, from where are you telling this? Are you simply telling your own opinions? We don't want your opinions. We want research, they will say in the open viva. Definitely for empirical data, your sampling, your number, everything should be correct. And the goal for all data collection is to capture quality evidence so that it translates into rich data analysis and allows the building of a convincing and credible answer to the questions that you have posed, right? And both the selection of appropriate data collection instruments and clearly delineated instructions for their correct use reduce the likelihood of errors occurring. Even in science, they do experiments, right? There it is experiments every day, maybe 1 year, really they will do experiments, quantify all the data, and finally they give a conclusion. But in legal research, we cannot do experiments in the lab. So the statutes, the legislations, the case laws, the interpretations given by judges, or the observations which you made should give you the correct the conclusion which you are giving. So there must be some proper justification in the conclusion which you are giving. For that proper justification, you need exact data. Without that, if you are giving, that is where we call, all the professors ask us, if you write one line also, where is the footnote? Come on, from where did you tell this? Right? So that gives us the credibility of our conclusion, and we can stand boldly and tell, yes, I have read this, or I have concluded like this because of this, right? Steps for data collection. It's not hard and fast rule. I just found out, or I just feel that this is how it should be. Define the aim of your research. Choose your data collection method. Plan your data collection procedures. Operationalization, that is, it will be in say some feelings and all, say in qualitative data. For example, how do you feel? Rate it under one scale, so you bring it into numbers, right? So operationalization, collect the data. So first you bring everything in order. Define the aim of your research. As I told you, that's the background which I was speaking to you from the beginning, that with what type of legal research are you going to do? What are you going to contribute? Be clear with that. Then only your method will be proper. And once you choose your method or tool itself, how you are going to proceed further. Because all topics, we cannot go directly and interview and come back. Many times it is not possible, right? So then only your technique can be correctly done. Operationalization, okay, feelings or how they are working, what is their working hours, or etc. Something like regarding the policy changes and all. If you want to ask, how do you feel? Are you happy with the law? If you ask, you have to ask them to rate it from 1 to 5. This is how I feel. Feedback forms and all we have seen, no? They ask you, and then you start collecting. You decide this and then go, right? And define the, when I say define the aim of your research, the process of data collection, you need to exactly identify what you want to achieve. So for that, first start by writing a problem statement. What is the practical or scientific issue that you want to address, and why does it matter? Right? Formulate one or more research questions that precisely define what you want to find out. Because if your research questions are clear, actually chapterization is easy. For that research questions only, you are formulating your chapters. Depending on your research questions only, you will need to decide whether you need qualitative data or quantitative data. Now, information, data, or sources for our legal research can be primary sources and secondary sources. Both can be used. Of course, in same, both can be used. It's not single, only primary, only secondary, need not be. It's mix and match. So when you say primary sources, the sources that contain authoritative records of law made by law-making bodies is a primary source. Statutes, legislations, rules, orders, bylaws, and authoritative decisions of the courts. All these are our primary sources. But on the other hand, if you speak to a person from economics or sociology or arts and sciences or something like that, they will say whatever we collect from the people only is primary sources. Don't confuse. In legal research, our statutes, our case laws, or our legislations are our primary source. From there only you are going to interpret, right? Don't confuse between that. Many times when we talk to them, we get a confusion. Oh, they are saying that as primary data. Okay, then what is my primary data? For legal research, this is what is the primary data. When it comes to secondary sources, are the one that refer and relate to the law while not being themselves. They are not directly, it's not a law, not a statute, but legal commentaries, abstracts, dictionaries, encyclopedia, etc. I will give an example of it. Secondary sources also are very, very valuable for legal research. Sometimes we feel I did not collect it myself, whether it is correct. For example, the government publications are a very good source of secondary data. For example, census data conducted every 10 years throughout the country, right? We all know. So, Registrar General of India conducting census, it is available in the website of them itself. Then we have Statistical Abstract India annually, that is by CSO, that is Central Statistical Organization, is conducting this study. This is a secondary source. And we have white paper on national income, which is published by the government only. So we will have it in their website. Annual survey of industries, monthly survey of selected industries, foreign trade of India, monthly statistics, wholesale price index, weekly all India consumer price index is coming in their website. It is available. Ministry of Commerce and Industry, economic survey, annual publication, national sample survey, national health survey. All these are very good sources of secondary sources which is available to us. So if anybody wants to write on that, or if your research is on that, and you can even check into that data also, use that data, provided you are citing properly that this is taken from the National Health Survey. That's all. So it's a very good source of data only, no problem. It can be taken from there also. Even non-governmental publications also, but authorized data are there, like company working results. Each company's website, if you go, they will itself give how they have worked out on it. Status reports of various commodity brands, commodity boards and all. Industry associations, for example, FICCI and AIMA, like this associations also publish reports. Export related data, retail store audit on pharmaceutical, veterinary, consumer products, national readership surveys, Thomson indices, like this. Enough sufficient number of data where we cannot go and directly collect, but it is available in their website with proper citation. They are a good source of secondary sources which can be cited in our legal research. Please make use of it also. But search, of course, nowadays it's easy because in Google itself everything is available, right? And then, okay, I have some problem with the yeah. Now, qualitative data and quantitative data, when it comes, it's mostly non-numerical and usually descriptive or nominal in nature. This means the data collected are in the form of words and sentences. Like questions like when you ask feelings, your intuition, your sensations, your choices, your consumer choices, we say, consumer preferences, we say. Somebody who studies on Consumer Protection Act need to know that. Even Competition Act, when you have to study on it, you need to know consumer preferences. So then qualitative data will help, and it captures things like emotions or subjective perceptions of something. So you need to have a survey question or something like that, and you collect. And qualitative data is expressed in words and analyzed through interpretations and categorizations. So qualitative data helps explain the why behind the information. Why? You are saying, so many people are saying this. Why did they say that? So the information quantitative data reveals. So quantitative data will tell number of people. Qualitative data will answer the question why they said like that, because they will have an answer for it. Okay. And quantitative data is numerical. I think it can be mathematically computed. Everybody knows that. Number of customers who will buy a product, 5-star rating, amount available, visitor spends in the library. All these are quantitative data. And it will be used in various scales, nominal scale, ordinal scale. You have to categorize. Actually, we need not worry about quantitative data now, I think. Collecting is important. Properly, if you have collected, computation and analyzing and all is now, I think packages are available. Computer itself is doing everything, or we have to get the assistance of a statistical person. It's very important. A researcher always tries to mingle with other disciplines also. Some things we do not know. We are legal researchers. I collected this data. What about my statistical? Kindly get the help of a statistical person. So if your aim is to test a hypothesis, measure something precisely, or gain large scale statistical insights, then I think it is better to go to quantitative data. If it's to explore ideas, understand experiences, then it is qualitative data. But no hard and fast rule. It can be a mix and match also, right? And doctrinal research. Everybody knows, I said everything in the library. So how to collect data, what to do? The domain is library, definitely. So what all you need to collect in doctrinal research, especially a legal researcher? Legal theories, principles and position of law that may be easily referred in the library. But we have to have a specificity on what we are going to collect, and the background information of it has to be collected theoretically. Many times we don't study, I mean, we are not ready to read the legal theories or jurisprudence behind it, how it evolved, all that things. So contents of the document are self-sufficient to be shown as good evidence of what law is on any issue. Cases. That's where I repeatedly tell cases are very good source for our doctrinal research, interpretations given by the courts. But we have to read the full judgment, compulsorily to be read. Without that, we must be able to identify what issue they have taken up, how they have answered this issue. So, ratio decidendi has to be clearly understood in a case. Then only for that, thorough reading of the judgment is very important. Journals. So good source, where do we get all this? Is books, journals, reports, magazines, newspapers, juristic works, reports of even seminars, conferences, symposiums like this. Right, your FDP is over. You have data available to you. Please read it. Please go through it once again. It's not once we read, we left it off. And literature containing factual and philosophical informations like article, research papers, thesis and dissertations, reports of commissions, court judgments, case commentaries, all these are our data. Legal research, doctrinal research data. Even thesis. Like when I see a thesis, I feel, oh, it's over, then what is that to do? Sometimes one thesis is the end. From there, another beginning starts. Because in every thesis, people will write, this is my limitation. I have done only this much. So why not think ahead? Right. So when the bill was about to come in a topic, somebody would have done a thesis and they would have said, okay, this bill must be passed with this justifications. But by then bill would have come, or it is an act now. So then we can study from further there. Right. When the act was passed, what happened? From there, we have to study further. Now it is e-library, modern advancement. So everything in your mobile or your laptop itself, you get everything. But all libraries, almost in all universities and colleges, there is a good source of e-resources also. Because sitting here, we can collect materials from US, no problem. So every researcher, doctrinal researcher, need to spend time in library to find out all these things. Sometimes even a newspaper report. Yes, continuously it will be reported. Why not? Even that becomes our data only, right? And participation, in fact, participation is another tool which, or technique I would say, which can be used both in doctrinal and empirical researches. When I say participation, it can be used by, it's an approach to obtain knowledge by participating in any activity where relevant information may be obtained from verbal statements and presentations. See, you are attending an FDP here. You got so much of information. So you are participating and actually collecting data for something. Somebody who wants to write on anything. And we have beautiful courses today, design certificate courses, or maybe symposiums are conducted. Some refresher courses specific on a topic is being conducted. Many things are happening. So that is participation. The researcher can sit there, participate in lectures, seminars, conferences, proceedings, academic and administrative judicial decisions, sit there, and they are also common sources of data collection, even for a doctrinal study. Empirical also, this is actually both, that also you can, but for doctrinal also, to write down the interpretations, how it is happening, participation is also a tool. Right? Now coming to empirical research, which our legal researchers have a little bit hesitancy to go, but it is not that tough. As I told you, if we are able to understand what question I am going to collect empirical data. I am reading on family law, right? I am collecting the cases, judgments, everything relating to, say, maybe property rights of women, Hindu women or a Muslim women. Something is my topic. I can even go to some Muslim women in a particular place. I decide my sampling, go there, ask them, get their information. So what is their feeling, everything I found out. Then I study the law. So empirical research for a legal researcher is one part of it, I feel, right? So actually there are many tools for that. One is observation, two is interview method, three questionnaire, all I think everybody knows, four is case study, and five and six is survey and scaling, right? Numbering it, right? So these methods are also or can also be used by a legal researcher. Nothing wrong. One hesitancy is when we talk to social researchers exclusively, they will say, oh, there's a different, they will actually analyze on, their hypothesis will be like, what is the relationship between this and this? There ends that research, social. There is no relationship between poverty and what is that, child labor. Suppose somebody is studying on it, they will say answer and they'll go off. A sociology person also can study on it. But a legal researcher, if there is no then what, how then answered, why child labor is prevailing in this country, how doctrines have developed on it, what was the committee reports which said that it should be abolished, what was the analyzation of that, all this we have to study and only we can report, right? So one by one, if you look into, observation is collecting or recording the behavior of the respondents or the sampling units. Here, the researcher has to observe the recorded or the phenomenon by himself. So he will be involving himself and the researcher will be able to keep an eye on the entire activity for the accurate data and certain direct inferences. The child labor, I'm studying on child labor. I must go to the place where child labor is happening and I observe why they come, when they come, what are the works they do, are they really working hard or what are, etc., etc. So I have to observe, right? Observation provides an opportunity for empirical study, which is first-hand information. We can read on child labor in books. Yes, definitely we can read, but that may not be the reality. So to know the reality, yes, observation technique can be done. And kinds of observation is participant observation, quasi-participant observation, and non-participant observation. Participant observation is the researcher being actively associated with the other members of the group. For example, I am studying on a tribal population. I live with the tribes. At least 1 month, I will be there with them. I am studying on a slum, I will be there with them. Yes, that also can be done. Quasi participant is I am not fully with them, but maybe I am studying on a specific topic. They, for example, tribal folk cultures. Even an IPR person should know that, right? That is being protected and all we say. To know that, you go there, participate in their festivals, their lunch or their sports or their food or everything, their culture alone I am studying. So quasi participant is sufficient. So whenever their festival is happening, I will go. Non-participant, the researcher remains neutral. He is nowhere there. He just observe outside. He does not take part himself in the group, but he remains limited to the causes of the observation, environment, population, or social life. I repeat, even legal researchers can do this. It is not only social. Suppose IPR, suppose GI, the geographical indication or something like that. You go there, find out what is the product, how this product is being promoted all these years. You talk to them, collect data from them. Yes, legal researcher also can do observation. And now interview. I think very common technique, face-to-face interaction with any person or group for the purpose of seeking certain information. So components of this is the researcher, the interviewer, and the interviewee, and the interview environment. So the researcher is the interviewer, and interviewee opposite side, interview environment. Yes, interview is also a very good technique because when we go to people and ask directly, for example, an illiterate person, if you write and give, if you send a mail and all, nobody will know. So even computer literacy, they might not know even if they are literate. So in that case, you go to them and talk. Say, for example, what public think about the law, what needs to be changed. If you go and interview, it will be good. The role of Supreme Court, we can study only by studying cases also, correct? But the impact of the judgment, yes, we can interview and ask. Say, for example, the judges itself, the judges' contribution, individual judges' contribution. Interview him. What did he think when he gave that judgment? Because we find that some jurists or sometimes some judges itself, after so long, after some years, they say that day, the judgment which I gave, I think I feel wrong. So interview method will bring about that view, right? And in interview also, so many types are there: structured interview, semi-structured interview, unstructured interview. Structured, specific, exact questions. Semi-structured, you have questions, but from what they say, you can pick up another question. Unstructured is you are not at all planned. Suddenly you saw, you are asking. That's all, right? And methods of research interviews, again, personal interviews, telephonic interviews, email or web page interviews. Nowadays, we see blogs and all. Interviews of people are coming in blogs. So modern methods have come. So nowadays, interview methods are also equally prominent and it can be done easily, no problem. And now coming to questionnaire. Slightly related only, interview and questionnaire. But in questionnaire, you don't see face to face, but you prepare a physical or electronic document consisting of predetermined set of questions, either printed, typed, or digitalized, and you distribute it. I think after Corona and pandemic, I think this is the most method which we find commonly used method or tool by various persons on such questions. It's useful where observation and interview is not possible. That's why we go like this. On each indicator, there must be questions designed and their language should be free from ambiguity, easy to understand and grammatically correct. In questionnaire, the drawback which I feel is that we might have framed a question in one way, but the person who read it and understood might have understood it in a different way. So in interview method, we have the question, we can explain the question. No, I am not asking that, I am asking something else. But in questionnaire, that's not possible. So while we frame questions for questionnaire, things must be very clear. And especially if we want to do it with some very low or I would say uneducated or illiterate people, then in vernacular language also the questions must be framed. Then only the questioner will become successful. Otherwise, we don't get the exact answer, or what we asked, we might not get. Case study. When I say case study, in legal research, there is a confusion. Don't confuse with the cases legal cases or the judgments. No, I am not on that. Case study is an in-depth study of an unit from the beginning to end. A person, family, institution, group, caste, community, or nation may be the unit for the purpose of the study. So here, case study method, legal researchers, when they take, maybe, as I told you, say property rights of only Muslim women, or Muslim women with special reference to this place. So you are only studying that. So they become, actually this case language is from, I think, medicine they use, no? Patients are their cases, like that. So those qualities of a unit are focused and analyzed. Only one group we are studying. So it will be focused, and it will be the subject matter of the study for the researcher. Only that group we will be studying. In legal research, on legal history of India, constitutional history of India, judicial contribution of any judge, academic contribution of any renowned educationist, and the life of an artist may be examples of case study method. So only one judge's contribution we are trying to study. Only that judgments we will study. Right, Justice Bhagwati on this, Justice Krishna here on this. That's how we get researchers like that also. Survey method is commonly used in social sciences and socio-legal researches, but surveys are conducted. In fact, I told you, the previous study, before even a law comes, schemes and surveys are conducted to know how, if the law comes or if law is not there, what is your problem, like that. So any social problem, through real public experiences, decide about the means of information. Most of the information is obtained through scheduled questionnaire, personal interview. So survey means we take up a survey, but the tools will be the previous one which I discussed. So before launching a survey, its units must be determined. It must be definite, appropriate in size, so that there is no generalized statement made on the basis of information. So while we are completely writing a report on the survey which I took, it must be correct. We must be able to conclude for the entire population. So for that, how did you collect, from where did you collect, becomes important. Scaling is another technique. Scaling means to measure something by using any unit of measurement, and it measures social behavior and attributes of man by converting qualitative facts into quantitative facts. Right? So what you do, how do you feel, or are you happy with the law? But you give a number, 1, 2, 3, 4, 5, just like feedback forms. If it is 5, you are very happy. If it is 4, you are little less, like that it will go. Right? How was the program? You ask, that is scaling, that number you give. So then you will be able, you are actually collecting qualitative data, but you will be able to quantify, because you are converting it into quantification by scaling is a method. So questionnaires and schedules are used as a source of applying this method. So these are some of the tools which I think for non-doctrinal research. I would like to end here by saying research is to see what everybody else has seen and to think what nobody else has thought. That's the conclusion of my side. And no method is good, bad, and all, we cannot say. Depending upon the changing nature of the social problems, their studying techniques also will vary. So thank you. Thank you very much for this wonderful opportunity. I would be happy to take up questions.